Good morning. Actually, yes, good morning, everyone. And thank you for joining us today for our Guided by Corner webinar series presented by Corner Management. My name is Andrew Batshaw. I am the Director of Client Services here at Corner, and I'm thrilled to have you join us for an important and timely discussion on reserve studies and New Jersey's ever-evolving legislation, specifically Senate Bills S2760 and S3992. As many may know, the tragic Surfside condominium collapse in 2021 really changed how our industry approaches building safety and long-term capital planning. And in the wake of that event, states like New Jersey have moved to strengthen requirements for reserve studies and structural integrity assessments. And today we're going to explore what that means for your community. We are so fortunate to have two exceptional experts with us. Brian Weaver, PCAM, President of Association Reserves, whose team helped shape the National Reserve Study Standards updated in 2023, and Steve Mlenak, partner at Greenbaum, Rowe, Smith, and Davis, and current president of CAI New Jersey, who brings a deep insight into the legal and legislative implications for associations and boards. Brian and Steve are going to walk us through the fundamentals of reserve studies, what they are, more importantly, what they're not, and explain how the new legislation will affect funding adequacy, disclosure requirements, and timelines for compliance. Little housekeeping note, uh, please, if you have any questions throughout the session, on your screen, you'll see that there's a Q&A button. Please put any questions that you may have in the Q&A throughout the session, and we are going to address as many of those questions as possible during the Q&A portion at the end. So on behalf of Corner Management, thank you so much for taking the time out of your day to invest in your community's future and joining us. And with that, we're going to get started. So Brian, I'm going to hand it over to you.
Sure, appreciate it very much, Andy. Thank you very much. The plan here will be to go through Reserve Studies 101 first. We're just going to give you a basic foundation on what reserve studies are, what they mean to community associations, et cetera, to build a framework. And then Steve is going to get into the legal aspects of the legislation and what it means to associations here in New Jersey. Next slide. So the reserve study standards have existed since 1998. Okay, when Surfside collapsed in 2021, they were updated in 2023. Our CEO of our firm actually helped craft those updated studies, excuse me, the standards. The purpose of the updating of these standards was to have consistency in terms of terminology, calculations, and expectations. So everybody, whether you're from Florida, New Jersey, California, it didn't make a difference. We have one consistent framework for what should be expected in a reserve study. Next slide. Okay, so let's start off with what a reserve study is not. I know I'm speaking to an audience here of board members. You may or may not know this. For managers, they have a little more information on this. They're engaged in this on a day-to-day basis. But let's start off with what it's not. It is not an invasive study. As reserve study professionals, we are not pulling off siding and looking at the sheathing. We're not doing core sampling of the roadways. We're not putting together a maintenance plan per se. While that's included under the New Jersey legislation, that's technically not what a reserve study is. It's also not a structural inspection. So that's a whole separate inspection. A reserve study is not any of these things that you see here on the screen. It's also not a construction document. It's not something that you would take and then turn around and have a vendor bid on a project for. Next slide. So what is a reserve study? The reserve study standards here, you'll see on the left-hand side of this screen, those are the National Reserve Study Standards. You can Google that. You can get those online. It defines a reserve study as a budget planning tool, okay? And it identifies the components that an association is responsible for, the status of your reserve fund, and a funding plan to offset those expenses. So those are the three parts. It's a budget planning tool, but those are the three parts of the actual reserve study standards. Next page. So as a budget and planning tool, it's not something you saw this in the old days before the legislation where communities would get a reserve study to check off a box, whether a bank was requiring it or they just felt it was so outdated that they needed to go ahead and update it, and then it would be shelved. We look at reserve studies very differently. There's a lot of moving parts in a year. So if you do a reserve study today, the shelf life of that reserve study technically is 1 year, while CAI might recommend 3 years and legislation requires every 5. The shelf life of a reserve study is really 1 year because there's so many moving parts. You've got projects that are taking place. You have inflation. You have the change in costs. You might have transfers from one account to another that you need to account for. Lots of reasons and moving parts that affect why it should be updated on an annual basis. Next page. So the foundation is getting the component list right. Okay. And it's essential. We have clients often that will ask for components to be removed from the study because then they don't need to be funding for it. But that's not doing yourself any justice. You want to make sure that you are accounting for all components that the association is responsible for. Now, there's some leeway when it comes to certain components, and we'll get into that in a moment, but getting that foundation right is key to the reserve study. Next page. So when you look at a reserve study, you're going to see a description of the components there in the left column. The UL is the average useful life of that component. RUL is the remaining useful life when we go out on site and we see that particular component. What do we determine, whether it's from the age of that component or what we actually see is the remaining useful life, and then the cost of that component. Every reserve study provider lays it out a little bit differently, but this is the gist of what you will see in a reserve study. Next page. So when we look at what should be included, it used to be a 4-part test. It's now a 3-part test. Okay, so long life components, those are components with a remaining useful life of greater than 30 years. So for instance, if you're a 5-year-old association and you have vinyl siding that might go 45 years, you have the right to be able to include that in the study or not include it. We include it as a company, and unless the client asks that it is not included. So remaining useful life of greater than 30 years, you do not have to include, but it should be identified in the study. So preventative maintenance needs to be identified as well. Inspection and report costs. So and project soft costs. So if you have a roofing project, for example, you're typically going to have professional costs associated with that, whether it be banking fees, engineering fees for developing the specs for that project. Those are to be included, not just the cost of the asphalt shingle. Components behind the walls and under the streets. So you have many associations have common plumbing lines, common electrical lines, sometimes common fire suppression system lines behind the walls. We need to create an allowance for that because at times you're going to need to do large scale replacements of that. That is a reserve study item because it is something that the association is responsible for. Next page. All right, the next part of a reserve study is the reserve fund strength. And this is where we determine how strong are your reserves. We hear it all the time from board members where they'll say, we have $1 million in the account, we're totally fine, thinking that $1 million is a lot of money. You could have $3 million of projects that are due the following year. So you are actually severely underfunded. Conversely, you might have $100,000 in your reserve account, but have no projects for the next 10 years, and you're actually potentially overfunded. So it really has nothing to do with the amount of money you have in the account. It has everything to do with how much you have in the account compared to how much you should have in the account. And that's reserve fund strength. I'll talk about that here in the next slide. Okay, so I use this analogy a lot. If you have a pool, for instance, and it has a 10-year useful life, and it costs $10,000 to replace, in theory, you should be putting aside $1,000 a year. So let's say by year six, you should, in theory, have $6,000 in the account. If you have $6,000 in the account by year six, you are fully funded. So if you had $10,000 by year six, you're actually overfunded. People think you have to have the full amount of that component in the reserve account. That's not an accurate statement. Conversely, if you had $2,000 by year six, you're actually 33% funded. So it's the amount that you've used up of that component that you have in the account. That's what determines if you're fully funded or not. Next page. So same example, here you go. If you're 5 years in and it has a 10-year useful life, you should have $5,000 in the account. Next slide. And in this case here, the fully funded balance, the column all the way to the right for all of these components is $154,100. Okay, that's the fully funded balance. It's the amount, the full amount that you should have based upon the annual rate of deterioration. Next page. So there's a misconception, like I've already talked about it here. It's not the total of the cost of all these items. So you see the fourth column over, the cost, 4,000, 10,000, 9,000, 5,000. You don't add up all those numbers. And if you have that amount, say you're fully funded, you're actually overfunded if you have all that cost. It's the amount that's been used up. Next page. Percent funded. So again, we get back to using a measurement to determine risk. If an association is in that 0 to 30% funded, there's a high risk for special assessment. If they're in that 70 to 100%, they are in a great position. Low risk for special assessment. Next page. So in this example here, if you have a fully funded balance, it says you should have $154,000, $100 in the account, and you have 154,100, you're 100% funded. If you had 300,000, you're 200% funded. If you had 15,000, you're 10% funded. Okay, so this is just key because it gives you an idea of how strong you actually are in terms of your amount in the account compared to how much you should have. Next page. So nationally, like I've already talked about, if you're in that 0 to 20% range, percent funded, there's a very high risk of a special assessment. And that's our goal. I know that CAI's goal as well is to avoid special assessments. Next page. Okay, so once we determine all the components, we know the reserve fund balance and how strong you are and what you need to do to catch up. We have to lay out a reserve funding plan. And this is what ties into a lot of the legislation. So we've got to put a plan together that works for the association. Next page. And that funding plan has four principles involved in it. Let me just focus on the one right now. It has to have sufficient cash, meaning it has to be adequate. And New Jersey put a small twist to that recently, back in August. I know Steve will get into that. But from a CAI standpoint, that is one of the guiding principles. Next page. So you have three different ways of achieving adequacy. You have full funding, which we just talked about. You have baseline, which is just keeping you above zero. And then you have the one in the middle, which is threshold. Threshold could be a 5% plan, a 10% plan. It could be a 20% plan. It could be a plan where the board says, we never want to go below $100,000. The threshold just means it's an arbitrary number that you're selecting that you say we never want to go below this amount. Okay, next page. So full funding, we want to get you up to 100% funded by year 30. That's the green line in this particular example. We're trying to get you to the point you should be where after 30 years of 100% funding. Next page. On this scenario here, this is baseline. Okay, it's gonna take your balance all the way down to zero, but not go below zero. And New Jersey defines that as adequate. CAI says that's adequate. This particular plan is now required to be in every reserve study. Next page. I'll talk just briefly about this and then I'll turn it over to you, Steve. From a standpoint of the requirements for the reserve studies. So there's a couple things. You have Fannie Mae and Freddie Mac. They underwrite about 70% of all loans. They have their own requirements, which has nothing to do with CAI, has nothing to do with the requirements of the state of New Jersey. They want to see updated reserve studies and boards following reserve studies and addressing issues that are pointed out in the reserve study in order for them to underwrite prospective home buyer loans. There's also insurance requirements. Association insurance brokers and underwriters want to see that the policy, excuse me, that the reserve study is being followed. There's ramifications if a board is choosing not to follow the reserve study requirements. And then obviously we have state legislation, which Steve is going to talk about. And I'll turn it over to you, Steve.
Thank you so much, Brian. And one issue that comes up routinely, and I want to just ask you because it was something you were recently talking about when we look at reserve studies over a period of 30 years, including those components that may not even come due to fruition over the next 30 years. Sometimes we're asked, well, if the law requires that we do this every 5 years, and CEI recommends, and others recommend that we do this every 3 years, why do we care what the funding level is going to be 30 years from now if we're updating this every 3 to 5 years? What do you say to that?
Uh, well, I mean, ultimately, you have a responsibility to plan for the future. So you're funding in order to get your association to a place where future owners are going to have the funds to replace those projects when they come due. That's the goal of planning in advance here with the reserve study.
Yeah, it goes back to what we talked about from the beginning that this is really at its core a budget, a planning tool. And the ability to plan now for the full 30 years, even though you're going to get a new reserve study in 3 to 5 years, it's going to give you as a board a head start when that new reserve study comes in that you're where you should be in general, in general speak. So
Can I
it is,
I'll
it is
add
important.
one other thing to that, Steve.
Yeah.
If you're not doing your part, if you're only looking at this in a 3 to 5 year window and you're just funding for those projects within that window, you might have major projects in year 6, 7, 8, 9, and the goal of a reserve study is to make sure you're putting adequate funds aside now so that you have that money in year 6, 7, 8, 9, 10, whatever it might be.
Right.
Not waking up in year 6 and you have to do drastic increases. That
Right.
breaks one of the guiding principles of our funding plan, right? You can't
Yeah.
have these drastic swings in increases.
Right. And going through as I do as an attorney to many, boards, and as I'm sure obviously you do, and Andy and Larry do as managers, there's no greater window into one's own personal financial habits than having conversations about capital reserve studies. We see it across the gamut from, people who want to fully fund because they're very conservative to people in active adult communities who say, why am I reserving for something where I'm going to be dead before you have to do it, right? So it runs the gamut, and the law that has come into effect has really demonstrated the real importance for associations to treat these things with the seriousness that it should have been all along. Because as you noted, Brian, you know, before these laws came into effect, this was something to check a box. You didn't really care what the components listed were. You didn't care when the useful life were. Yeah, it was a tool, and sometimes you followed it, sometimes you didn't. But for the most part, as we all as business partners and professionals for associations see, because almost all of our associations are struggling to maintain that financing because historically they haven't followed their association's capital reserve studies. They weren't funding in a level appropriate to make sure and ensure that projects were being done when they're supposed to be done and not being put off. And that's when you get roadways littered with potholes and roofs that are riddled with leaks that you're patching constantly, or special assessments and loans and the interest that comes with that. So the whole intent behind this is yes, there's going to be some short-term pain, but once associations get in that rhythm of having consistent and routine studies done and following those funding levels, the days of special assessments and loans should theoretically be gone. They'll never fully be gone because sometimes estimates don't pan out, but theoretically they should. So I'm going to talk about the laws that were enacted. As Andy noted from the beginning, a lot of the genesis of this came from the tragedy that happened down in Surfside last year. And much of that is attributed to the fact that they didn't have the money necessary to make the structural repairs to that facility that were necessary. And I'm not going to say that was everything, but that's certainly a component of it and opened a lot of people's eyes. So last year, New Jersey became the second state in the country to adopt a law such as this. There are two components to that law. One is structural integrity, and sometimes the bill, specifically S 2760, is lumped into that nomenclature. The whole thing is the structural integrity law. But really, there's two components of it. There's structural integrity, which is certain buildings that qualify or eligible as a building that is subject to that law are required to have routine structural inspections done. But the second part of that law, which generally applies to every association. The only associations it does not apply to is those with common property or common elements valued at $25,000 or less. That is very few. When you think about even HOAs, where all that exists, their entire purpose of being is a detention basin. That's valued at more than $25,000. So there's going to be very limited exceptions to getting out of this. So you should assume if you're on this call, you're obviously a board member, you're a committed one because you're trying to be educated on things such as this. I'm sure your associations are required to comply with this. So the law that was initially passed last year, which Community Associations Institute, if you're unfamiliar, CAI, which is the largest worldwide organization that advocates for members of communities and the partners that work in them, was very involved in drafting the legislation. And of course, like all good legislation, it's, you don't want to know how the sausage is made, but there's a lot of twists and turns, and it wasn't exactly what CAI wanted, but it is, for the most part, a positive bill because it does address some of the significant concerns and issues that we were seeing. The initial bill had different parameters than what we're going to be talking about now, that is the effective law. So if you've heard things such as, well, if it's, over this amount of my budget, I have 10 years to make it up, or if it's under, I have 2 years to make it up, and things like that, I want you to try to just forget about that, because that causes a lot of confusion. And to this day, when board members try Googling or searching about this law, you'll find a lot of articles that look recent because they were written 6 months ago or a year ago that talk about things like that are not really the case anymore, because that law was amended. You see a second bill number on your screen here, S 3992. And the intent of that cleanup bill, I'll call it, was to try to make sense of this or make it a little bit more clear than it was in the original version. Right. That's what it does. So you heard Brian go through what a reserve study is, and you also heard what the different options are for funding. You have the full funding, you have the threshold, and you have the baseline. What the law provides now is a clear description of what is required to comply under that law, which is, at a minimum, baseline funding, meaning that you will fund not one penny more than you need to ensure that over the next 30 years, the projection by your reserve specialist is that you will never dip below $0 in any particular year. But that also means you will not contribute one penny less than that. That is the baseline requirement. You will not find any reserve specialist, manager, or attorney that will recommend doing that. However, there's many circumstances, and certainly I have many clients that were so far behind, the 8 ball, that baseline really becomes all that can be done. And I don't say that lightly, because I tell many associations, I'll have associations that'll call me and say, we can't afford this. There's an uproar. We cannot do this. And then you look at the numbers and they're talking about, a $20 increase a month. And I say, no, you can do this. You don't want to do this, but you will do this. Okay. That's not what I'm talking about. I also have associations where we're talking about increases of $1,000 a month if we were going to go to anything higher than baseline funding. So there is a specific fact analysis that needs to be done per association to ensure that they're complying with the law and also doing what's necessary and the best for their association. The law provides a fourth option, the nuclear option here, that you can comply with and still be legal under the law, but it is highly discouraged. I do not have an association that has done it. I have many who've inquired about it. And that is here, you'll see the third bullet point on your screen, which is the 85% funding plan option. The law provides that for the next 5 years, okay, if you can't fund to baseline, you have an option to fund 85%. Okay. And that is a calculation that no reserve study is going to automatically give you, or at least I haven't seen them automatically provide that math. That is something you would have to go back to your reserve specialist and together with your team calculate what that amount is going to be. But it would mean, in essence, you're underfunding your reserve by 15% of what it should be under the law. Now, the law allows you to do that for the next 5 years, recognizing that there's going to be a period of catch up. But there's a big catch. If you are going to opt to do that underfunding, you are required prior to the adoption of your budget to issue a written disclosure to all owners in your community in 20-point bold font that the board has elected to underfund the reserves. And by virtue of that underfunding, it is estimated that a special assessment is going to be needed in a particular year and at a particular amount. All of that needs to be in that notice. Now, I've been asked before, does that notice also have to go to prospective purchasers, right? A lot of times, usually a prospective purchaser that's looking to purchase a unit, their attorney or their title company will reach out to the association's management company and request something called an estoppel letter, and ensure that at the date of their purchase, they're not buying any liabilities. And coupled with that, there's going to be a lot of questionnaires from the lenders to those prospective buyers. They're going to ask about the last structural inspection. They're going to want to see the budgets. They're going to want to see the reserve studies. And that information is going to be disclosed, whether we like it or not, to those prospective buyers. My opinion is that under the law, technically the association's obligation is only to notice the current owners. And then the obligation to notice the prospective buyers shifts to that owner currently. However, my advice, notwithstanding that, is as an association, if you are going to choose to underfund in accordance with the law and have that disclosure to the owners, you best also notice your prospective buyers to avoid, when that special assessment does come down, a lawsuit or other claim that, even if defensible, is going to be a claim against your D&O policy and affect your premiums, right? So don't consider this option lightly. It should really only be used in the very, very 0.1% extreme cases in New Jersey. Okay.
Hey, Steve, could I just point
Yes,
out
Brian.
one quick thing, if you don't mind? In
course.
terms of the example, and I don't want anybody to get confused with they hear 100% funding, they see 85%. The percentages, I don't want you to get confused here. If our baseline plan said that you need to contribute $100,000 this year to stay just at zero at some point in the next 30 years, you have the right to do $85,000. That's the 85% we're referring to, right? So you're going to be going below baseline. But I just want to give that example so people see the 85%, they might get confused there, but that's what it refers to.
Right. And another point I want to talk about is, when is compliance required? I was telling, before we started the call, I was telling, Brian, that I had an association just a couple of nights ago that read into the law what they want to read into it. And you see that happen sometimes. The original law that was adopted, which became effective on January 8, 2024, provided that associations must comply within 1 year. So if you take a year from that enactment date of January 8, 2024, that puts you at January 8, 2025. So all associations were required to fund in accordance with that law in January of 2025 of this year. I had an association 2 nights ago say, well, why are we worried about this now? Because when they amended the law a couple of months ago, that restarted the clock. That 1 year restarted. So we have until August of 2026 to worry about this. Not true. Not the case. That amendment specifically didn't extend that time period. So Every board member that is listening to this, every manager, every association is right now required to be in compliance with this law, meaning that it is October 31st. A lot of you have gone through, maybe many of you are in the process right now, if you're a calendar year association, of going through your budget process. That budget should be providing for adequate contributions to your reserves in accordance with the law. And then finally, and we did mention it before, the law does not allow your studies to go beyond 5 years. Every reserve study needs to be at least 5 years or younger, or newer rather. However, CAI and reserve specialists around the country are recommending 3 years. 5 years is the law, 3 years is the recommendation. Okay. And we've talked about a lot of these components of the new law. One other point that I want to address with respect to the reserve studies is the politics of it all, right? A lot of times boards are reluctant because nobody likes seeing maintenance fees go up, right? Nobody likes bills going up. Nobody likes inflation. Nobody likes any of that. And if they say they do, they're lying, right? But this is the reality. And this, what I have tried expressing to associations, at least my boards, is to, instead of viewing this as the negative, right, that a lot of people are, use this as a tool politically to defer the blame from you and get your association back into good standing, into a place of financial health without taking the heat, right? If you wanted to do this 2 years ago, politically, I know that would be tough for a lot of board members. I know that would be tough for a lot of associations to say, hey, your maintenance fees are going from $200 a month to $300 a month just because we want to put more money away for 20 years from now. That's a hard sell. That's a real hard sell to people who are not, understanding of these particular issues. But now, by all means, if you want, by all means, hey, this is the state of New Jersey for you. This is what they're making us do. Shame on them, but guys, we have no choice. We have to do this. If that's what it takes to sell this, I tell them that's fine, because this is the law, and at the end of the day, that is the healthy thing to do. So I don't know if we have any other slides on this, Brian. I think that covers in terms of what the law is, what the law requires. And I guess we're happy to answer any questions.
Yeah, I think
Absolutely. Thanks, guys. So we have a question in here, and this will probably go to both of you. Why would any HOA want to fund more than the baseline if some senior owners are concerned about paying more for the future years? What would be a reasonable explanation to the owners? And I think, Steve, I think you just touched on that a little bit, but maybe you can allude a little bit on that.
Yeah, no doubt. So at the end of the day, if you're living in an association, you are an owner in property. You are an investor. And yes, you live there. It is your home. It is your property. But what you own is an asset. It is an investment. And the association's charge, first off, is to keep everybody safe. But second off, is to ensure that they're maintaining or elevating your property values. And as I said before, when an association is answering questions of a lender or prospective buyer, that is undoubtedly going to include what are our funding, how are the reserves funded, what are our budgets, how has the association been keeping its finances in check. And I can tell you, as somebody who represents individuals and families who are buying into it as their attorney, and we look at that, I do counsel them on the financial health based on how much is in the capital reserves. And an association that is funding higher than baseline and protecting themselves from estimates that may be off or components that may have a useful life that goes well before expected are in a much healthier point of view than those that are at simple baseline. And therefore, the property values are positively affected. So I tried to, think of this as if you were a single family, home. Okay, if I'm selling my home with a brand new roof, my home is way more valuable than with a roof that is 30 years old. I know I may be selling this house in 2 years, and my roof may have a 5-year useful life on it, and I may not get the benefit of that roof in 5 years if I'm not living here. But maybe I put that roof in because it's going to enhance the value of my property, and I view the reserves the same way.
Thank you, Steve. Another question here. We have a sidewalk with about 100 slabs. If the board has a policy to inspect and repair or replace slabs every year as needed, does the cost of the entire sidewalk need to be included in the study?
I'll answer that. So what we do for most associations, especially for curbs and sidewalks, is we do an annual or every 5-year allowance. You're rarely going to rip up all the concrete slabs at one time and replace them. So we'll break that into every 5 years, a percentage of the cost of the full replacement.
Thank you, Brian. Another question. What is the best way to track the capital reserve study from year to year? Should you work with a live study?
So I think, okay, well, there's two parts to that. One, I would do an annual update, number one, but any reserve study is actually not, it's not tying into your accounting software where we're tracking the actual live feed of your project. So that would be more on the accounting side with your management company or internally. You'd be tracking that, the actual projects. But whatever you do on an annual basis does get incorporated into the reserve study. We'll account for all of that into the reserve study, especially if you're doing annual updates.
Great, thank you. Question, and I would assume that this means the driveways are common. Is driveway paving cost considered a reserve or a deferred item?
Well, hey, oh, go ahead.
No, go ahead. I mean, it just depends upon what your governing documents, what it says. Well, you talk about the paving itself would not be deferred. No, we would classify that as a reserve. But if you're going to do seal coat and repairs, some clients wish to classify that as a deferred or preventative maintenance. We include it in the reserve study.
Great.
Yeah, exactly what I would say.
Thank you. This one will probably go to Steve. Should we be documenting every step of our reserve planning process for legal protection?
I'm not sure I understand the question exactly. Brian, do you? What are you documenting? Well,
Yeah, I
the
think it's
reserve
from.
study itself is certainly documented.
Mhm.
It's a document that, is going to be adopted by your community at an open meeting. It's going to be available to all the members to review and ask questions of, associations that are going through this in the right way. They're going to accompany Brian or any other reserve specialist, on their walkthrough. They're going to meet with them, identify concerns that they may have. So there will be active participation in the process by the community, if that's what the question is.
Yeah.
Yeah, I think it's probably from a liability perspective for a board. Now, what are there recommendations as far as they're going through the process of what bids they're getting, who they're talking to, the advice they're taking, what considerations they're giving into when it comes to making their funding determination, recommendations on documenting that?
Sure. So every board in New Jersey, I've yet to see the association that doesn't have language in its bylaws that indemnify the board members first for doing anything that is within their powers and duties and responsibilities to do. And on top of that, you're obviously covered by D&O coverage. And when a claim like that is filed, so for example, and as an attorney, you can appreciate every time somebody in the association is aggrieved or feels like something went against the way they wanted it, the first thing you hear is the F word, right? Fiduciary duty violation, right? You're violating my fiduciary duty. I'm contacting my lawyer and we're going to sue. And for every 3,000 of those, we get one of them that actually follow through with them. But when such a claim is filed, and in the context we're talking about today, it could be you, as a board, you chose to fund at threshold or full funding, and we can't afford that, and the law only required baseline funding. So you're overcharging us over that the law requires. Now, I can tell you that's a bogus claim. You were elected to make decisions such as that, and in court, you would be defended and you would have the evidence of not only the law, but all the recommendations from professionals around the country as to what funding levels are appropriate for communities which are above baseline. But you would also have the record, as you mentioned in the premise of your question, the record of everything that was done, including who you hired, to do the reserve study, and hopefully it was somebody qualified and licensed and permitted under the law to do that. Check one. That you would have a reserve study that complies with the law. Check two. And that you adopted it at an open meeting and made it available to the members. Check three. And if you follow all of those steps, you would be, protecting yourself under New Jersey law from a claim. Now, the question is always asked of lawyers, could we be sued? And what people really mean is, could we lose? Because the answer to could we be sued is always yes. You could be sued for anything in America. The real analysis is, will they prevail? And if you follow the law, they won't prevail.
That's great. Thank you very much. Okay, with that, I want to thank Brian and Steve for sharing their expertise and helping us make sense of this incredibly critical topic. As we've learned today, reserve studies are more than just financial tools. They're an essential planning document that helps to ensure the safety, sustainability, and the long-term health of every community. If you have additional questions or would like help assessing your community's readiness under the new Jersey legislation, please reach out to the team at Corner Property Management or to Brian and Steve, and we have their contact information up on the screen. All of us are here to support boards and association professionals through every step of compliance in the planning process. This session is part of our ongoing Guided by Corner webinar series, so please be sure to follow us on Linkbook and Facebook and Instagram for updates on upcoming educational events. And on behalf of Corner Property Management, I'd like to thank everybody for joining us today. And again, thank you so much to our presenters, Brian and Steve, for their time. We appreciate you. We appreciate your time, your commitment to your communities, and your partnership. So I wish everybody a great afternoon, and thank you so much, and happy Halloween.
Thank you for having us, Andy.
Thanks, guys.
Thanks,
Take care.
Andy. Take care, guys.